rebuttal time if the court.
4 minutes, okay?
Yes, sir. Thank you. Your Honors, this case presents what my research indicates might be a case of first impression, which is how the Board of Medical Examiners is implementing the statutory authority to assess costs, actual costs, and reasonable costs. It's actual and reasonable costs to a practitioner like my client, Dr. Waggoner, following a contested case hearing. And as the record reflects, in this situation, Dr. Waggoner is an internal medicine physician in Cookeville, Tennessee, who was provided a notice of charges alleging that he was overprescribing opioid medications to a number of patients. This was a very long, drawn-out process that eventually resulted in a significant contested case hearing that lasted, I think, for about 10 days, spread out over a period of time of about 18 months. And during that entire contested case hearing, the department presented evidence, Dr. Waggoner presented evidence to a panel of 3 members of the Board of Medical Examiners, presided over by an administrative law judge, as is customary in these situations. And the record reflects that all the way up until the very end of the contested case hearing, including in closing arguments, the Department of Health sought the revocation of Dr. Waggoner's medical license. Nothing short of that, essentially the death penalty for him as a practitioner in Cookeville.
Counsel,
Yes,
while
sir.
the department didn't get that, and isn't there a fairly significant limitation that's been imposed here? And you have probation, you have monitoring, you have fines, and this seems like more than just a don't do that again. I mean, there's significant limitations that put on this doctor's practice.
I agree, Your Honor. There were limitations. I could debate how significant they were. He continued to practice medicine. There was a limitation on his ability to prescribe opioid medications. There were consequences to the probation that were reflected in reimbursement and things like that. So yes, he was penalized. From our perspective, Your Honor, it is reasonable to require the Board of Medical Examiners to engage in a deliberative process to determine whether the results that were obtained against him in comparison to the requested relief of revocation of...
Is that before us, or is just the cost issue before us? I mean, isn't the only thing we're really here on is the amount of the cost and whether
Yes.
it's appropriate or not?
That is correct, Your Honor. I would respectfully submit, however, that in determining those costs, there should be, under the law, a deliberative process so that this court can review the Board of Medical Examiners' decision and determine whether they assessed actual and reasonable costs.
Do you
And
mean some sort of findings of facts? Or?
Yes, yes, sir. Because here's how the board handles it up until this very day. At the end of a contested case hearing, the Board of Medical Examiners issues an assessment of costs within 60 days of its ruling. That assessment of costs is a one-page document, I quoted it in my brief, that has headings or categories of the costs without any breakdown of the costs, without any time entries by the attorney, and, Your Honors, without any deliberative process about what the evidence that the Board of Medical Examiners heard, the results obtained, and whether that full amount is reasonable under the circumstances. And that's what we're concerned about.
In this case, though, when it goes back after the Chancery Court's first round,
yes, sir.
And the board has an opportunity to review the entire record of the case, there's much more specific evidence provided in terms, and we get into details of how many hours were spent at the copy machine the second round. So much of your argument, it seems to me, is perhaps focused on the first round and not the second round, in terms of what about, was there a mistake after the remand that's made here? I mean, what's wrong with the process or procedure that was utilized the second time?
I agree, Your Honor, that there is a difference in procedure in terms of what happened from the remand from the Chancery Court with instructions that the board deliberate. That is when I had an opportunity at the time of the remand to actually engage in discovery and obtain the information that no one had seen, not even the Board of Medical Examiners. So yes, there is a difference there. However, Your Honor, I would respectfully submit that difference does not impact the analysis of whether there is fair and procedural due process in this decision, because first of all, it's not the same panel members.
Have you developed that argument in your briefing on appeal before this court? And is there authority that you've given in support of that?
I've not found any authority that says that a subsequent panel can determine what was actual and reasonable cost as required by the statute when the subsequent panel is not the panel that actually heard the evidence and
What
could
about the
engage.
rule of necessity?
I'm assuming, Your Honor, the rule of necessity, I'm not familiar with that particular
Yeah,
rule, but I
well-
can understand why it might be necessary with retired board members, might be what the court is thinking about.
Yes. The rule of necessity says that if in this case, the judges who did hear the case, if you say they're not appropriate to hear the case, but there's no one else to hear it, so they have to hear it.
Yes, they have to under the circumstances. I'm arguing, Your Honor, that the circumstances violate the provisions of the statute in terms of who finds what's actual and reasonable costs, who determines the standards so that this court or the Chancery Court or any court can actually review
But
what was
if you look
decided.
at the whole statute, we find that these people who heard it before can't hear it. They're not on the board anymore. Their term's expired. So you either have to have the new panel hear it or you get off scot-free.
I respect, well, Your Honor,
That's what you're wanting.
well, yes, it is, because of the procedures involved here. Just because the board is the architect of the problem you just identified, Your Honor.
Well,
Because the board
perhaps the
could have said
legislature is.
I'm sorry, sir.
Perhaps the legislature is, but we can quibble on that.
We can, well, that brings up this inconsistency in the statute, which says they have to be actual and reasonable costs, but then they say the board can just say, hey, nothing to exceed X, and we're done. And I wonder if
Well,
this court is
I mean, I guess-
worried about that.
So what I hear you arguing is you're looking for a system before the board that's analogous to what we do in a trial court, where if there's an attorney's fees, the trial judge then makes a determination, are they reasonable or not? Sometimes the trial judge may take expert testimony, although in most cases they do not, because they know, in our cases of hell, they don't have to, because they know what's going on here. But here, the entity that is setting the cost, and part of that being fees, is an entity that doesn't have that expertise, right? I mean, you're not going to necessarily have a lawyer on this board. In fact, you're likely not to have a lawyer.
Probably a good thing, yes, sir.
Yeah, so they're not going to be familiar with the concept of reasonableness in this. It sounds like to me that the statute makes what you're advocating for a bad fit for the type of process that we would employ in a trial court.
So I hear that, Your Honor, but I don't think that giving my client or anybody who appears before the Board of Medical Examiners an opportunity to engage with the actual panel who made the finding, to comply with the statutory obligation to determine what is actual and reasonable costs and not arbitrary and capricious.
Didn't you have that opportunity when this was sent back by the Chancery Court? I mean, you had an opportunity to examine witnesses, present evidence, testimony, explore whether it was the actual and reasonable cost. And the board, and different members of the board, but they made a determination that those were actual and reasonable costs.
That's why I'm here, though, Judge, because I respectfully submit that determination was not based upon an actual deliberative process. If you look at the quotes that are in the brief, they did not, all they said was, we've got the bills, we've got this, we've got that, and we're not going to engage in any other analysis. They did, and I was blocked from presenting any evidence about what the revocation versus what the results was, because it was solely focused on what the charges were and whether they were actual or not. But you're right, we did have an opportunity on remand, but that does not cure, Your Honor, I respectfully submit, does not cure the fundamental flaw in the way the board is managing this process. And Judge McBrayer, I agree it's not a good fit when the panel doesn't have a process, a due process, to set a date when the Board of Medical Examiners or the Department of Health presents the actual costs that they say are reasonable, and hear evidence as to that, and give Dr. Waggoner an opportunity to challenge them.
And so
before
would
the
that
very
necessarily require then expert testimony in every case, as particularly someone that can testify to the reasonableness of the cost associated with the fees of a government attorney?
Not necessarily, but it could. I can't offer an argument that says there should not be an opportunity for expert witnesses. I am struggling with the notion that we get a full and robust hearing on the charges, but we don't get the same consideration when it comes to assessing costs and fees. Why is that? Because it's inconvenient? I respectfully submit that is not the way the Board of Medical Examiners should handle this and comply with the statutory and constitutional grounds of procedural due process, and making sure that their decision is not arbitrary and capricious, and gives you a record from which you can review and make a determination as to that. So I respectfully submit that this was no reasonable process, not due process.
Your time is up for
Okay,
now.
all right, thank you, Your Honor.
Thank you.
Good afternoon, and may it please the court. My name is Ryan Gallagher. I'm here on behalf of the Board of Medical Examiners, along with my co-counsel Sarah Sedgwick and Rachel Appelt. In 2019, the Board of Medical Examiners found Dr. Waggoner guilty of several violations of the Medical Practice Act. Those violations primarily involved overprescribing. And as Judge Usman mentioned, significant discipline was imposed. He was put on probation, required to have a practice monitor, and required to do additional training, among other things. The board also imposed $7,000 in civil monetary penalties, and it assessed about $97,000 in costs under 63-1-144. Dr. Waggoner appealed only the cost issue, and the Chancery Court remanded the case back down to the Board of Medical Examiners because the department didn't provide evidence to justify the $97,000. Well, on remand, the department provided that evidence. The Chancery Court then affirmed, and this court should affirm the Chancery Court and the board for three main reasons. First, the evidence that the department provided justified its actual costs. Second, those costs were reasonable given the facts and circumstances of the case. And third, the board fully complied with due process.
So what evidence did the board receive then on the reasonableness of these particular fees in this case?
The reasonableness question, Your Honor, really speaks to the facts and circumstances of the case. So the evidence was primarily the notice of charges from the original contested case, the final order from the board from the contested
So
case.
is the board then comparing the seriousness of the charges in this case versus the series of charges in other cases and what fees were awarded in the other cases, and then determining, well, this range is reasonable?
The board is considering the nature of the allegations, the fact that this was an overprescription case, that it involved at least 14 patients. You know, each of those patients is going to have thousands of pages of medical records. An expert witness was going to be required to testify to the standard of care regarding whether or not overprescription was occurring. et cetera. So I think the board, the remand panel had a sufficient background to assess whether or not the costs incurred were reasonable. And considering it was an overprescription case, which is a very involved kind of prosecution, it's not exactly straightforward to prove whether or not overprescribing has occurred.
Did the panel initially said costs no more than $100,000, right?
Yes, that is correct.
Where did
Your
they
Honor.
get that figure?
That figure came from the final order. Well, it was put in the final order by the board. It was adopted by the department submitted a proposed
It
order.
was a proposed order that they adopted.
That's correct, yes. And the proposed order said $100,000. The notice of charge.
And explain why $100,000 was the appropriate amount? Is there any, or is it just sort of stated as a conclusion and the board adopted it?
I mean, that amount, Your Honor, was presumably based on the department looking at its costs that it had incurred, and then when it put it in its proposed order, $100,000, that matched up nicely with the $97,000 that was ultimately assessed.
There are a number, my understanding there's some affidavits in this case. Do any of them say, do we have representation from a lawyer who worked on a case and said, I attest that my work on this was reasonable and consistent with normal and good practice, anything to that effect?
The lawyer who primarily handled the prosecution, Andrew Kaufman, had left the department at the time the remand panel had its hearing, so there's no specific, there's not an affidavit from Andrew Kaufman, no.
How does a panel of non-lawyers determine whether the amount of legal work is reasonable or not in a case? I mean, I understand how they could see the complexity of it as a medical issue, but how do they determine whether the legal work that was invested, how hard of a legal issue was it or not? How did they make that determination as non-attorneys?
I agree, Your Honor, that's a difficult decision for a bunch of doctors to make in this case. But I think the way that they handle it is based on their previous experiences. I mean, they've been on the board, they've seen these overprescription cases litigated, and so from that experience, they can attest whether or not it was reasonable generally.
Do we know what the experience of the original board was for hearings?
The deliberations show that quite a few of the members that were on the remand panel had heard overprescription cases. Ms. Claxton, she testified specifically about the results obtained, because petitioner or appellant has commented on that a lot, that the board didn't consider the results obtained, but she clearly indicates in the deliberations that she considered the results obtained, and she shows familiarity with these kinds of cases. So on page 763 of the record, she testifies, from what was entered into evidence in this case, I can tell you that it absolutely would have been at a minimum of probation to a revocation, depending on the ones that I have sat on and listening to other board members. Probation is a restriction on a license. It's a reportable offense. So it's not that he got handed something that wasn't restricted. So she considered the fact that the department had initially sought revocation and achieved probation.
But I guess what I'm missing in there is where she also would go on and testify, and I had another probation case, and the attorney's fees there were $90,000, or the cost there were $90,000, and this fits in line with that. That's not here in this record.
That is correct, Your Honor. I mean, the statute tasks the board with determining the actual and reasonable costs. And so the board is simply following the statutes. Yes, it's not made up of a bunch of attorneys, but they do their best based on the evidence that's presented to them. And in this case, the record shows that the evidence was sufficient to justify the $97,000.
Did the evidence at least show how many hours Mr. Kaufman worked on the case and his hourly rate?
Yes, Your Honor, it does. The department submitted a cost spreadsheet, and that starts on 774 of the record through 798. And it's a detailed breakdown of every single hour that Andrew Kaufman spent on the case.
Was it all at the $65 an hour rate?
Yes, that is correct, Your Honor. It's off $65
And then what about paralegals that were working on the case?
The paralegal rate was $39 an hour.
You work cheap.
Now I'll speak to the due process allegations that the appellant has raised. First of all, in the administrative context, the requirement for due process is notice and an opportunity to be heard. And since the cost issue is the only issue before the court, it's clear that the appellant, Dr. Waggoner, got a full hearing on the cost issue alone. He was able to present evidence, he was able to cross-examine witnesses, had discovery, etc. So he had a meaningful opportunity to contest the costs that were assessed against him. And that's all that's required for due process. His argument that the board panel should have been the same board that heard the contested case hearing also is contrary to the statute. All the statute requires is that the board be the same. It requires under 63-144, it says that the board that heard the contested case has to be the board who assesses the costs. It doesn't say it has.
Argument developed in the appellant's brief. I understand the issue is stated. Is the argument developed in the appellant's brief on that point with regard to having the same board members?
I believe it's included in the issue statement.
Is it developed in terms of actual argument?
Not really. I believe there's a few stray mentions to it that the ALJ erred by not granting the appellant's motion to dismiss, but I don't think it is developed at length, Your Honor.
Isn't there a motion to reconsider process in before the board? I mean, once the costs were submitted within 60 days, could the doctor at that point ask the court to, or the board, excuse me, to look at those numbers again?
That is correct, Your Honor. 45317 under the UAPA.
So there is a mechanism to get the exact same board members to hear a review of the costs submitted after they. Does the timing of that work out okay though? Because it's 60 days after the board's decision. Is it what would be the time limit then for the doctor then to challenge the cost?
So under 45317, I can't remember exactly how long you have to file a petition for reconsideration. I think there's a good question as to whether that timeline would start once the order's issued or once the final assessment of cost is issued, because the doctor wouldn't know really whether he wants to file a petition for reconsideration until he gets that actual number. So I think there'd be a good argument that that would be the date that would trigger the time period for the motion for reconsideration. But in this case, he did not file a motion for reconsideration at all.
So your theory is the statute just requires the board as an entity to hear it again, to hear the costs, not the identical members of the board. Is that your theory?
That is correct, Your Honor. The statute simply says the board. It doesn't say the same panel members. But also I'll say too, I mean, the rule of necessity that you mentioned, Your Honor, is applicable here. I mean, the board members who heard the contested case were no longer on the board. So the board didn't really have any option other than to reconstitute a new panel with new members. Otherwise, it would have had to just ignore the instructions from the Chancery Court, which was to hear evidence on the costs.
No one actually briefed anything about the rule of necessity. It's one of those sort of obscure little things that one doesn't run across very often. Would the parties have any objection to briefing that afterward and submitting briefs to us? Okay.
No, Your Honor.
We may put down, I haven't discussed this with my cohorts here on the panel, so we may put down an order that does that. I just wanted to see how you felt about it. Thank you.
And lastly, I'll touch on the rules of professional conduct issue. With the Chancery Court, when it initially remanded it to back to the board, it instructed the board to consider the rules of professional conduct for assessing attorney's fees. Most of those rules were simply not relevant to assessing an attorney fee amount for a government attorney who's salaried. So the board didn't explicitly include those factors in its final order on remand, but the Chancery Court, when it affirmed the remand panel's order, it mentioned how basically none of these factors are really relevant, and it had no issue with the board not explicitly mentioning those factors. But as I mentioned, the deliberations do show that they considered at least factor number 4, which was the results obtained. They considered the fact that Dr. Waggoner was given probation as opposed to revocation, which the department had originally sought. So they did take that into account, even if they didn't explicitly put that factor in to the final order. And if there are no further questions from the court, the board respectfully requests that the decisions of the board and the Chancery Court be affirmed. Thank you.
I see no other questions. Thank you.
Your Honor, a statement was made that I just respectfully want to take some issue with, which is that the board assessed costs of $97,000+, meaning really the panel assessed a ceiling for costs, and it was an administrative function where the Department of Health, through the Attorney's Office, submitted a document setting out a breakdown of those costs. And it is correct that there are time entries that were submitted during the remand hearing that were obtained during discovery, along with a policy of the Board of Medical Examiners that attorneys are obligated to enter their time within 30 days at the conclusion of a contested case hearing. Now, absolutely, you mentioned this, Judge Bennett. I seek on behalf of Dr. Waggoner that the assessment of costs be reversed. That is the relief we seek, and it is based upon the absence of fair and procedural due process in the way the board is managing their statutory power as vested by the legislature to assess costs and attorney's fees. And on page 29, and Judge Usman, I apologize for not having as robust a briefing as you have mentioned a couple of times before, and I regret that. And on behalf of my client, I apologize to the court. But on page 29 of our brief, we set out the extent of the deliberations by the original panel, where they brought up the issue of civil penalties, and then he said, Dr. Ali said, I strongly feel that the cost of this issue to the state should be reimbursed by the respondent. Dr. Beckford said, sure. With an upper limit, the state suggested $100,000. Then he says, I assume, that's on the basis of the time the case is taken. Sure, we're placing a limit. That's it. That's all that occurred.
And then that, in effect, becomes an anchor for the board.
Absolutely.
In any review.
Yeah.
It anchors the number, and so anything under that amount ends up being de facto actual and reasonable.
Exactly. I can't think of a more arbitrary process. And although I took some issues with, in my briefing, of some comments that were made by the remand panel, I think that it's reasonable to be sympathetic to their circumstances. 10 days of a contested case hearing and not hearing the evidence and being able to sit in judgment. So, for example, the state's own expert witness testified that no one was harmed by Dr. Waggoner's prescribing practices.
Now, the board, though, did have the benefit of getting an idea of how much your client spent in attorney's fees.
Which I objected to relevance at the time, and that number was wrong, but without a doubt, Your Honor, I charge more than $65 an hour.
I would hope
And
so,
I will-
Mr. Wiseman. I
Well,
would
thank
hope
you.
so.
I appreciate that. I respectfully submit that's not relevant to a fair assessment of.
Well,
what is
but,
reasonable and
I mean,
actual.
but when a trial judge is setting the number, they do look at that.
Well, if given the opportunity, I'll be able to correct that calculation by Dr. Waggoner, but that's not in the record, so I won't rise to do that. Thank you.
All right.
Thank you. Thank you both, or all of you. Would you call the next case, please?
Sean Corin versus Reagan